Oh, good afternoon and good morning for all those joining from London. My name is Catherine Grims. I'm the International Policy Advisor at the Law Society of England and Wales. And I'm delighted to welcome you today to this joint event between the Law Society of England and Wales and the Law Society of Hong Kong. Today we will hear from experts in two panel discussions. The first panel will be on cross-border dispute resolution and the second on challenges and solutions to gender inequality for women in law in Hong Kong. But before we begin, I'd like to remind you of some administrative points regarding the Zoom webinar, which is kindly being hosted by our colleagues in Hong Kong today. First, participants will automatically be muted and are in listening mode only for the duration of the webinar. However, the chat room allows you to send messages to the host, the panelists, and the attendees. And there will be time for Q&A after each panel discussion. So if you have any questions for the speakers, please do type your questions into the Q&A box during or after the session. There will also be a small break between the panel discussions today. For more detailed instructions regarding the Zoom webinar functions, please refer to the chat message posted by the Law Society of Hong Kong. And that's all from me. So I hope you enjoy the discussion today. And I now wish to introduce the President of the Law Society of Hong Kong, Melissa Pung, and the President of the Law Society of England and Wales, Stephanie Boyce, to provide the opening remarks. And with that, may I please now hand over to President Melissa Pung.
President Boyce, distinguished speakers and moderators, ladies and gentlemen, good day. Welcome to the webinar jointly organized by the Law Society of Hong Kong and the Law Society of England and Wales. Exploring new opportunities for members is an important task of the Law Society of Hong Kong. Over the years, we have established extensive connections with overseas bar associations, laying a good foundation for collaboration on activities that are of interest to our members. The Law Society of England and Wales is our devoted, unfailing partners throughout the years. We work hand in hand to advance the legal profession in both jurisdictions. We value exchanges and cooperation and are keen to explore new opportunities. To formalize our commitment to collaborate and to support each other, a memorandum of understanding was signed in October 2017. Since then, we have multiple high-level meetings and discussions on ways to enhance the profession's competency and professional standards. There's no doubt we'll continue our effort in exploring ways to foster collaboration and to strengthen our members' exchanges. Because of the pandemic, almost all the physical seminars and conferences have been cancelled. Fortunately, with the help of technology, we are grateful to remain connected. By this webinar, we hope to remain abreast of major development of the legal markets in Hong Kong and the UK. It is encouraging to know that today, over 150 members have registered. We are very grateful for the overwhelming responses. Globalization creates more cross-border trade and investment opportunities for enterprises and professional services. The extensive use of technology in business transactions and expansion of e-commerce has also sparked demands for legal services that are unrestricted by cultural, geographical, and language boundaries. In this webinar, our speakers will talk about the latest development in cross-border dispute resolutions in the UK and Hong Kong, including the development of arbitration, cross-border enforcement of judgment, insolvency, and restructuring, and more. The Law Society of Hong Kong places high importance on the values of diversity, inclusiveness, and equality. We encourage members to do the same. These aspirations are the prerequisite to a sustainable practice environment, one that is free of discrimination with no barrier to equal opportunities. In the second part of the webinar, Our speakers will share their insights and personal experiences on the challenges and solutions to gender inequality. I hope you'll find today's webinar informative and rewarding. I look forward to seeing you again in the very near future. Thank you.
Thank you very much, President Pong. And I'd now like to introduce the President of the Law Society of England and Wales, President I. Stephanie Boyce.
Thank you very much, Catherine, for the introduction, and thank you very much, Melissa Pang, for inviting me to speak today. As colleagues have already said, I am the President of the Law Society, and it's an absolute pleasure to be able to open this joint event with the Law Society of Hong Kong and to speak alongside President Pang. I would like to thank you all for all you have done to convene today's discussion. With around 30 UK firms and almost 1,200 English and Welsh qualified solicitors in the jurisdiction, Hong Kong is the biggest overseas destination for our members. That is why events like today are so important. They provide an excellent opportunity for legal professionals to share knowledge, develop connections that matter, and show the legal sector at its global best. Similarly, we greatly value our strong relationship with the Law Society of Hong Kong, whether through joint activities and events like today's, supporting trade missions, or other channels for sharing insight and best practice. We will continue to develop and strengthen the links between our jurisdictions. And this relationship is mutually beneficial. England and Wales remains an open and welcoming jurisdiction for lawyers from Hong Kong. I know many members from both jurisdictions value the ease of working across borders, and long may that continue. Today's programme neatly demonstrates how well placed lawyers are across the world to address the challenges our profession faces and to utilise the opportunities before it. The past 18 months have tested our connections in unprecedented ways. But despite this, the international legal community is as strong as ever. Throughout the pandemic, lawyers have worked calmly to keep legal systems moving and thriving. And it is our international bonds that have helped to support this. So some of our discussion later today will address developments in cross-border dispute resolution. And we can clearly see how cooperation enables members of both our jurisdictions to share best practice and be prepared for changes in the legal landscape. Innovation represents opportunities for all of us, and I'm sure the session will see a wide-ranging and reflective discussion among the knowledgeable panel. Our second session today demonstrates what Force for Good Lawyers can be. The panel reviews the challenges and solutions to gender inequality for women in Hong Kong. The legal profession has made great strides to improve gender diversity in recent years, but there is still more to do and further steps that we can all take. Addressing inequality is a core priority of my presidency of the Law Society of England and Wales, and it's my mission to leave the profession more diverse and inclusive than the one I entered. Our latest data shows that over 50% of practicing solicitors in England and Wales are women, and that women from over 60% or form over 60% of new entrants into the profession. Yet there is still underrepresentation at senior levels, with only 31% of partners in private practice being women. In 2018, the Law Society conducted an international survey to find out why that is the case. And with the support of the International Bar Association, Women Lawyers Interest Group and LexisNexis, nearly 8,000 people completed our Women in Law survey, the largest undertaking on this important topic. Approximately 250 roundtable discussions took place across 5 continents within 21 jurisdictions in 30 cities and involving approximately 5,000 women and men in the profession. Our research identified that the key obstacles to women's career progression were unconscious bias, cited by 52%, unacceptable work-life balance demanded to reach senior positions, cited by 49%, and traditional network routes to promotion being male-orientated, cited by 46%. An overwhelming 91% of respondents to the survey cited flexible working as being crucial to improving diversity. Yet only 52% reported working in an organisation where flexible working is in place. Creating a more flexible, inclusive working environment gives those with care responsibilities equal opportunities for progression and helps create a more diverse senior leadership. Driving forward equality in the profession is an international task, and I'm heartened by events like today that will play an important part in revealing the obstacles, bringing a diverse range of experiences together and dispensing the solutions we can put in place. So before I hand back to Catherine, I know today will allow for fascinating discussion and in-depth examination, covering two areas of importance to the legal profession. It is also deeply pleasing to be able to work jointly with the Law Society of Hong Kong to deliver these opportunities for our members to connect globally. Thank you very much, and please do enjoy the sessions ahead. Thank you.
Thank you very much, President Boyce. And with that, I would like to now hand over to Ms. Evangeline Kwek, our moderator for the first session on developments in cross-border dispute resolution, to begin the sessions today.
Hello everyone, good afternoon. I'm Evangeline Kwek, the Managing Partner of Stevenson Harwood Shanghai office. Ordinarily, barring COVID, I would be in Hong Kong hosting this panel in person. Unfortunately, because of COVID, I won't be able to join you in person, but thankfully, because of technology, I'm able to join virtually. I'm very privileged to be invited by the Law Society of Hong Kong and the Law Society of England and Wales to moderate the first panel today, where we will discuss developments in cross-border dispute resolution. The format that this panel will take is that each of the four speakers will actually give short presentation on topics that relate to the general theme of this panel. Each presentation is supposed to take between 5 to 7 minutes, and then after which we will discuss questions that some of the attendees today have already raised before the session, or during the course of these presentations. If you have any questions, please raise them in the chat box, and we will try our best to answer as many questions as possible. As far as possible, please do try to keep these questions relevant to the topics. So let me introduce myself very quickly first, before I briefly introduce each of the panelists. I've been a common law practitioner since 2006. I started my career in Singapore. I practiced in Singapore for about 2 years, and in 2008, I moved to Hong Kong. In 2009, I managed to obtain my Hong Kong law qualification and my England and Wales qualification. In 2017, I moved to Shanghai, and I've been based here ever since. Before COVID, I would travel frequently to Hong Kong to work with my Hong Kong colleagues on various Hong Kong matters. I'm a commercial dispute resolution lawyer, focusing mainly on marine and international trade. I've certainly found my multi-jurisdictional experience to be very useful in my day-to-day handling of cases. So turning to the panelists. Today we have 4 panelists. The first panelist is Ms. Adelaide Luke. Adelaide is a partner at Herbert Smith Freehills. She is the head of their competition practice in Asia. I thought that I had the most number of qualifications on this panel, but actually Adelaide holds the distinction of being qualified in 4 jurisdictions: England and Wales, Hong Kong, Australia, New South Wales, and Ireland. Perhaps unsurprisingly, her presentation will focus on competition law disputes, choice of forum, and the impact of Brexit. Mr. Edward Liu, like me, is a commercial dispute resolution lawyer with a particular focus on marine and international trade. He has achieved the enviable distinction of being qualified in England and Wales and also in the PRC. He is a partner at Hill Dickinson, and his presentation will be on the interconnection between English law and Hong Kong law from a maritime arbitration perspective. Our third panelist is Heidi Trey. Heidi is a partner at Stevenson Wong & Co. She is the head of Dispute Resolution Department and the Banking and Finance Department. She's also a member of the International Legal Affairs Committee and Arbitration Committee of the Law Society of Hong Kong. Her presentation will be on the latest developments in Hong Kong in respect of insolvency and restructuring law. And our fourth panelist is Ms. Karen Lam. Karen is a senior associate at Seyfarth Shaw LLP, and she is also a council member of the Law Society of Hong Kong. She specializes in dispute resolution, and today her presentation will be on the enforcement of UK judgments in Hong Kong. Without further ado, I now pass the metaphorical mic to Adelaide.
Thanks very much, Evangeline. It's a pleasure to be here today. Before I start, I want to thank the Law Society of England and Wales and the Law Society of Hong Kong for organising today's event. As Evangeline mentioned, I very much come from a competition law background, and so I'll discuss a few aspects of cross-border dispute resolution through that lens, through that perspective. Before I came to Hong Kong in 2015, I spent many years in London and Brussels, so I have a fairly good grasp of the competition on that side of the world. So we don't have too much time today, so I'll get through quite a bit of material in the time available. I want to focus on the dispute resolution mechanisms that are available to parties that want to resolve competition law issues. And I'll touch on the more formal mechanisms today. I won't talk about mediation. I'll go through arbitration, private court actions, and regulatory enforcement. And one of the key points to flag at the start is that your choice of mechanism varies depending on the jurisdiction at issue. And actually determining jurisdiction in competition law issues isn't necessarily as easy as looking at the law or the contracts. I won't spend too much time on that particular issue, just to say at the outset that the relevant competition law to apply in any particular dispute is that where the conduct has an effect or where the agreement was implemented. So you can have a distribution agreement governed by, for example, Hong Kong law, but if the distribution takes place, for example, in the UAE, it is the competition law of the UAE relevant to the resolution of that particular dispute. So, apologies. Looking at arbitration a bit more closely, the question of whether competition law issues are arbitrable is something that's developed independently from jurisdiction to jurisdiction. As a starting point, most jurisdictions recognise that competition law involves matters of public interest and public policy. And so these public policy considerations have been quite important in figuring out the extent to which competition or antitrust disputes can be resolved by way of arbitration. So under English law, for example, competition law issues are generally arbitrable as far as the competition law affects the rights of the parties themselves. The effects on the public at large aren't arbitrable, and that generally means that remedies have to be that can be awarded by arbitrators are more limited. They have to be focused on the rights of the parties themselves. By contrast, in Hong Kong, disputes arising from the competition ordinance here aren't arbitrable. And that's because the ordinance confers responsibility for enforcement to the Competition Commission and the Communications Authority, as well as the Competition Tribunal. In particular, Section 108 of the Hong Kong law, the ordinance, specifically provides that no independent proceedings can be brought where the cause of action involves a contravention of the competition, i.e. the first or second conduct, broadly equivalent to Chapter 1 and Chapter 2. Okay. So you can see that there's some divergence as between the jurisdictions. China is an interesting one, and that's had some recent developments. And this is an example of divergence within a jurisdiction. So we have in China 3 relatively recent cases, 2 involving accusations of cartel conduct and 1 involving an accusation of abuse of dominance. So the first case was August 2019, and that the Supreme People's Court indicated there quite firmly that competition law issues weren't arbitrable under PRC law. And we had a second case in December 2019 where a claimant brought an action alleging loss as a result of cartel activity. And the allegation was that the vendor had participated in the cartel, and so the claimant had paid an artificially high price for the purchase of those goods, which was power cables. The sales contract between the parties has a clause stating that disputes under that contract should be subject to arbitration. But the case was dismissed on the basis that the conduct in question was horizontal monopolistic conduct, basically cartel conduct, And this wasn't within the scope of the clause agreed between the parties, and so it couldn't be subject to arbitration. The SPC held that the dispute went beyond the confines of contract law and into the realm of public policy. So finally, we had a third case last year, which, as I mentioned, related to the abuse of a dominant position. And here the dispute arose between a supplier, Shell, and its distributor. The distributor accused Shell of various abuses, including excessive pricing, discriminatory treatment, and exclusive dealing. A significant issue was whether or not these allegations could be heard through the courts, given the underlying law was the anti-monopoly law, the earlier judgments, or whether they could be addressed through arbitration. Now, after several jurisdictional track challenges, the court held that this type of dispute was closely related to the performance of the contract, and therefore it could be subject to arbitration. Moving very briefly to standalone actions, I think the main point on this one is to say that the positions differ quite starkly depending on where you are in the world. But they are quite clearly precluded in Hong Kong, as I mentioned, by Section 108 of our Competition Ordinance, whereas in England and Wales, they can occur and are in fact encouraged in some circumstances. Enforcement activity is again something that, well, it's something that varies by jurisdiction depending on enforcement priorities, but there is broad convergence among jurisdictions that have active competition law regimes. Competition authorities generally welcome complaints about anti-competitive behaviour and have generally set up hotlines through which they can receive complaints and triage them in terms of their enforcement priorities. So all of this is to say that if there is conduct that affects the interests of a party in multiple jurisdictions, it may be that different mechanisms are invoked in each. I haven't had time to touch on follow-on actions for damages, so I'll move straight to the impact of Brexit very, very briefly. You can see on the slide that there is limited impact, I think, in terms of the arbitrability of competition law issues and the availability of standalone actions, and that's because these are functions of national law. The main change, I think, as a result of Brexit is that the Competition and Markets Authority will be applying the UK's Competition Act 1998 rather than the EU law, Article 101 and 102 of TFEU. I think there could be changes in the level of regulatory activity as the UK Competition and Markets Authority seeks to take on more and larger cases that perhaps were previously handled by the European Commission. I think the issue on follow-on actions for damages, the answer to that is yes and no, and that's partly because the withdrawal agreement will provide for follow-on action damages to be brought in the UK for some time yet. And finally, in terms of cross-border enforcement, I don't think there will be too much of a change there, and that's largely because the UK authority will already be focusing on UK subsidiaries and UK entities that are engaging in anti-competition. And with that, I'll hand over to Edward.
Yeah. Okay, thanks very much. And good morning and good afternoon. It is really my great pleasure to be here and invited by the Law Society of Hong Kong and the Law Society of England and Wales to join today's panel discussion. Very briefly, as Evangeline kindly introduced, I'm qualified as a solicitor of England and Wales and also a lawyer of PR China, and soon to be a Hong Kong solicitor. I'm a partner of Hugh Dickinson LLP and leading the office China practice and the Chinese market. And my main practice is commercial litigation and arbitration. But today I will share my views from a maritime arbitration perspective. And in today, my short presentation, I will cover three issues: the substantive law and procedural law, and arbitration to be held in Hong Kong, English law to applied, and finally, the enforcement of arbitral awards. Arbitration rather than litigation in the courts, as we all know, have becoming more and more popular dispute resolution mechanism for resolving cross-border disputes against a diverse legal and cultural background. In practice, different systems of law may apply to govern different aspects of an international arbitration. Broadly speaking, we can just broadly speaking that we can break them down to as the substantive law and the procedure law. Substantive law is the law governing the subject and merits of the dispute. It is sometimes referred to as the applicable law, governing law, or the law of the contract. In most jurisdictions, the parties are at liberty to choose the law that governs the contract. And on the other hand, the procedure law of the arbitration is referred to as the lex arbitrarii or curial law, which will depend on the seat of the arbitration. The procedure law determines to what extent the local courts will be involved in the process, namely any formalities to be complied with, the extent to which the arbitration agreement excludes court jurisdiction, how much autonomy and discretion the parties have in choosing the arbitral procedure, the extent of support that the court will give to arbitration, whether the arbitral award can be appealed and its time scales, and the enforceability of the award and the grounds of challenges. The major part of my presentation today is about the arbitration to be held in Hong Kong and English law to be applied. Very often in maritime and commercial arbitrations, parties would choose to insert an arbitration clause, for example, say, arbitration to be held in Hong Kong, English law to be applied. For example, this is exactly the arbitration clause in a 2015 English case named Shagang South Asia and Daewoo Logistics. English law and Hong Kong law are two closely bonded and interrelated jurisdictions. They are indispensable to the development of cross-border dispute resolution, and that is probably why there are plenty of international law firms from the UK, as the president of Law Society of England and Wales just mentioned, setting up offices here in Hong Kong. In reality and in practice, English law is the majority and dominant choice of substantive law in maritime and commercial contracts. Why do parties prefer English law to govern their contracts? First of all, is because of the large body of judicial precedents and the consistency and fairness of English courts and arbitration tribunal. This offers parties with the legal certainty. Secondly, is about the English common law principles, which highlight the freedom of contract and party autonomy. Thirdly, English law has the global reach due to the historical reasons, and we all know that, as I said, the common law jurisdictions are basically the countries who are governing the contractual world still in the for time being. So very quickly referring back to the Shagang case, the Daewoo commenced arbitration against the Shagang in London. Shagang argued that the seat of the arbitration was Hong Kong and that the applicable procedure law was therefore Hong Kong law. Therefore, the Hong Kong Arbitration Ordinance applied. Wales Arbitration Tribunal made an award on its own jurisdiction, finding that English law governs the conduct of arbitration proceedings. The English Commercial Court set aside the arbitral award and concluded that arbitration ought properly to have been subject to the Hong Kong procedure law with a Hong Kong seat. So the significance of this case is that unless the parties have clearly and expressly or provided to the contrary, the law governing the arbitration procedure will be that of the seat of the arbitration. And in particular, in this case, Mr. Justice Hamblin also notably made a very positive comment in his judgment about Hong Kong arbitration and judiciary. He said Hong Kong is a well-known and a respected arbitration forum with a reputation for neutrality, not least because of its supervising courts. And of course, I would like to echo Lord Hamblin's remark. Over the years, Hong Kong has emerged as a popular choice of venue for arbitrations. And also, for example, like this year, that Hong Kong has been ranked as the third preferred choice of arbitration venue by the Queen Mary's International Arbitration Survey. Very briefly, and about the enforcement of arbitral award, which I know that my learned friend Karen Lam will elaborate it further in detail. The decision of the arbitral tribunal referred to as an award is normally final and binding, and it can be enforced in the court with the same legal effect as a court judgment. And Hong Kong is a party, is a signatory party to the New York Convention, out of 168 state parties to date are also the signatories to this convention. That means the Hong Kong award can be enforced in these jurisdictions. Beyond that, Hong Kong is also, as Hong Kong is a part of China, there are separate mutual arrangements between Hong Kong and mainland China in relation to the arbitration award enforcement, and also intermeasures to aid the Hong Kong arbitration. According to the report issued by the Chinese Supreme People's Court last year, I understand that it is extremely rare for a mainland court to refuse to enforce a Hong Kong judgment, Hong Kong arbitral award. So that's also, I think, the reason why Hong Kong arbitration is getting more and more popular. So as I said, you will listen more details from Karen about the enforcement of the enforcement issue. And now I would like to pass my mic first to Heidi, talking more about insolvency from a cross-border perspective.
Thank you, Edward. Thank you. Good morning and good afternoon, ladies and gentlemen. I'm Heidi Choi. I'm a partner of Stevenson Wong & Co. I'm a member of the International Legal Affairs Committee and the Arbitration Committee of the Law Society of Hong Kong. I'm an arbitrator, mediator. I'm also a China appointed attesting officer. So it gives me a lot of pleasure to meet you online today and to share the latest developments in Hong Kong insolvency and restructuring laws. There has been a lot of developments in this area of law, and recent decisions could shape the future of how companies in financial distress would conduct its restructuring and which forum creditors would choose to pursue recoveries. It is very important to know these because in the post-pandemic situation, I'm sure there are a lot of businesses will face a lot of difficulties in restructuring. And because of time constraint, I will only give a snapshot of the important cases and the key takeaways. I'm going to give a snapshot of 3 aspects. First, I'm going to share the recognition and assistance of foreign insolvency proceedings. In recent years, Hong Kong court has extensively granted recognition and assistance orders, commonly to facilitate the work of offshore liquidators. Hong Kong court has inherent jurisdiction to grant a letter of request to permit Hong Kong liquidators to seek recognition and assistance in another jurisdiction. The first case is a very important case. It's called Shanghai Huaxin International Group Limited. It is the first time that the Hong Kong court granted an order for recognition and assistance to mainland liquidators of a mainland China incorporated company. 2 criteria must be satisfied. First, the foreign insolvency proceedings are collective insolvency proceedings. Second, they're opened in the company's country of incorporation. There are also some important principles on how the common law power of assistance could be exercised. First, it is not available to enable foreign office holders to do something which they could not do, even under the law by which they were appointed. Second, it is available only when it is necessary for the performance of the foreign office holders' functions. Thirdly, an order granting assistance must be consistent with the substantive law and public policy of the assisting court. The court stressed that the purpose is to maintain the principle of collectivity and pari passu distribution. The second case is the China Boursa case. In that case, the court granted an order for recognition, refused to grant general assistance because the way the joint professional liquidators approached the matter failed to satisfy the court that they were protecting the creditor's interests. And this is the first time the Hong Kong court refused to grant general assistance. The third case is Re Ando Credit Limited case. This is the first application for appointment of professional liquidators over a Hong Kong company with the purpose of seeking recognition in mainland China. The application was granted to enable Hong Kong liquidators to recover the substantive receivables from debtors in mainland China. And then in May, that is in two months ago, we have a breakthrough. A very important cooperation mechanism was signed on mutual recognition of and assistance to bankruptcy proceedings between PRC and the Hong Kong courts. The arrangement covers 3 pilot cities, Shanghai, Shenzhen, and Xiamen. In gist, a liquidator in Hong Kong may apply to the relevant intermediate people's court for recognition and assistance. and administrated in mainland bankruptcy proceedings may apply to the Hong Kong High Court for recognition and assistance too. And on last Tuesday, very fresh out of the oven, on the 20th of July 2021, we have the first case. This is the hottest decision everybody should know. The hot case in point is Samson Paper Company Limited, a decision just handed down last Tuesday. It is an important decision where the Hong Kong Court ordered for the very first time, under the cooperation mechanism, the issuance of a letter of request to the Shenzhen Intermediate People's Court, seeking its assistance in aid of the company's liquidation and its liquidators. The company was incorporated in Hong Kong and ran business in Hong Kong. The center of main interest, remember these magic words, COMI, center of main interest, was in Hong Kong. Now, the key takeaway is that prior to this case, a liquidator appointed by the Hong Kong court or a court outside of PRC has never been formally recognized by a PRC court. We anticipate that more cases will be coming in to seek recognition in China and vice versa. We now come to the soft touch liquidation. Let's start by looking at the traditional approach in Relegend International Resource Limited 2006 case. In that case, it was held that under the Hong Kong law, provisional liquidators cannot be appointed for the sole purpose of propounding a restructuring. However, in recent years, the Hong Kong courts have held that the lack of power to appoint provisional liquidators only for facilitating restructuring and corporate rescue does not prevent the courts from recognizing and assisting foreign liquidators appointed for that purpose. So in the second case, the Moody case, which is a 2020 case, joint professional liquidators were appointed on a soft touch basis in Bermuda to explore and facilitate the restructuring of a company. The court granted recognition order, but with express indication that they will not have the status as if they were appointed as if provisional liquidators in Hong Kong. And then in the Lam Tech case, that is this year's case, a 2021 case, provisional liquidators were appointed in Bermuda. The court held that Lam Tech did not have credible plan to restructure its debt. And hence, what they tried to do is to engineer a de facto moratorium, which we don't have in Hong Kong. And hence, a winding order was made immediately. The key takeaway is that the court is more skeptical towards the use of soft touch liquidation as a technique to stall the creditors winding a petition in Hong Kong court. The court will scrutinize very carefully the prospect of the restructuring plan and will not easily accede to application for adjournment for the purpose of assisting offshore soft touch liquidation. And finally, a very quick word on our corporate rescue bill. In Hong Kong at present, there is no statutory restructuring procedure available under Hong Kong law, but it is possible for creditors of Hong Kong company to negotiate an informal contractual restructuring agreement with the company. But this will in general require the cooperation of all creditors of company. So that is very difficult to achieve. And in 2014, Hong Kong government published a detailed legislative proposal of a new statutory corporate rescue procedure and insolvent trading provision. With the impact brought about by the COVID-19 pandemic, the number of corporate failures is expected to increase. So in June 2021, Hong Kong government indicated that it would continue to engage stakeholders to refine the legislative instructions. So a couple of key features on the new corporate rescue bill. We're proposing to have a moratorium finally of 45 days. We'll have provisional supervisor, and we will also have insolvent trading provision. We look forward to seeing the implementation of the corporate rescue bill to assist businesses to sustain and survive in these challenging times. Let me pass the floor to Karen, who will share more tips on cross-border enforcement of judgment. Thank you.
Thank you, Heidi, for the informative update on insolvency law. Hello, everyone. My name is Karen Lam, and today I'm asked to talk a bit on the enforcement of foreign judgments, in particular UK judgments in Hong Kong. So I am today speaking in the capacity as a council member of the Law Society of Hong Kong, but by way of background, I'm also a disputes lawyer. I'm currently a senior associate at Saifa Shaw, and I've been practicing basically general commercial litigation like my fellow speakers, and I'm also a credit mediator, and basically I would my focus is on commercial litigation, mediation, regulatory work, compliance, domestic litigation, etc. So how to enforce? Because of the time, I was told that we've only got 5 minutes each. I will briefly touch upon the regimes and the enforcement procedures in Hong Kong. First of all, the regimes. In Hong Kong, because there's no bilateral or multilateral treaties for reciprocal recognition and enforcement of UK judgments, there are only currently two statutory regimes available in Hong Kong, which is the Foreign Judgments Reciprocal Enforcement Ordinance, what we call FJREO, and the Mainland Judgments Reciprocal Enforcement Ordinance, MRJEO. For the statutory regime, for foreign judgments, it only covers 15 jurisdictions at the moment, which includes, for example, jurisdictions like Australia, Austria, Belgium, France, Germany, etc. But unfortunately, this does not include the UK at the moment, not England and Wales. And for the MRJEO, that only covers judgments from mainland China. And on the other hand, in the England and Wales, although UK is part of multiple bilateral and multilateral international treaties for reciprocal recognition and enforcement of foreign judgments, the statutory regimes are also not applicable to Hong Kong. So what can you do to enforce a UK judgment in Hong Kong? In short, we have to follow the common law regime, and you must bring a claim in the courts of Hong Kong in order to enforce. So for judgments to be enforced, there are several considerations. It must be in personam, and it must be in the nature of a monetary reward, which is for a liquidated sum. It must be a final and conclusive in nature, unrelated to tax or penalty, and there's no issue with jurisdiction. And by that, it means there's no challenge of jurisdiction in the UK. And according to my understanding, it's similar to in England and Wales. So besides those several points I've made just now, and there are other considerations if you want to enforce a UK judgment in Hong Kong. First of all is the limitation period. A judgment creditor has 6 years from the date of the foreign judgment to commence proceedings by writ in Hong Kong to recover the judgment sum as debt. And this is similar in the UK. And other considerations besides the limitation period, if you want to enforce a UK judgment, is whether you need interim relief. For proceedings that commenced in a place outside of Hong Kong, under Section 21M of the High Court Ordinance, there is a provision which provides that interim relief may be sought by the parties in aid of foreign proceedings. For example, you can apply and you can seek for a Morava injunction, Anton Pillar orders, interlocutory and preservation orders. So in relation to the procedures to recognize a UK judgment, well, under common law, a foreign judgment is recognized only if it is a proof of a valid debt that can be sued on, and the judgment will be given directly by the Hong Kong courts. So once a judgment is recognized under common law, it is prima facie enforceable. And usually you would commence an action by way of writ, and it must be served on the defendant. And if the defendant does not show up or does not state its intention to defend, you can apply for default judgment. And it's not covered in the slide, but there's also a possibility of getting a summary judgment, which I'll deal with it later. So once a judgment is obtained, it can be enforced just like any other Hong Kong court judgments. And once you have obtained a Hong Kong judgment, there are other enforcement actions which you may consider taking. For example, you may apply to the court for a garnishee order. This is very common. It is like an order compelling the bank to pay what it holds on behalf of the judgment debtor to the judgment creditor. And for this, you must be very, very careful. If you must have the bank information on hand, and then that would be like you must have all the bank details, etc., so that you can proceed to garnish the monies in the bank account. And second of all, which is also very common in Hong Kong, is applying a charging order. That is, if the defendant has a property or shares in the company, you can apply for a charging order over those properties. And of course, there's also less common, but it's available, is a seizure of goods order. So I will touch upon briefly on cybercrime, because internet fraud and cybercrime is it's happening frequently. And what happens if you have this situation? And then basically you need to take action swiftly. And then it is also possible in Hong Kong to apply for a moratorium injunction by ex parte for a freezing order. And then at the same time, you can also apply for banker's books orders requiring the banks to disclose information such as bank statements on concerned accounts. And also you, at the same time, you may consider the application under Section 21M to enforce worldwide moratorium injunction. So because of the time, I'm told that I've used up all my time. Thank you very much. I hope you've enjoyed my very brief introduction on the enforcement regime in Hong Kong.
Thank you, Karen. Thank you, Adelaide, Edward, and Heidi. I found the presentations really interesting, especially the mention of Samson paper. Certainly, I'm going to read the judgment right after this. We have not had any questions. We did have a question that was raised before today's session. So to give the panelists a break, I will answer that question first. The question is, please compare the pros and cons of selecting UK arbitration versus London courts as dispute resolution mechanism, and why do UK financial institutions prefer the London courts jurisdiction over UK arbitration? As Edward touched on, I think London courts traditionally, it's a tradition to choose London courts in financing documentation as the dispute resolution forum. A large part of it is because a lot of the precedents are from the Loan Market Association, and that those documents provide for the English courts to have jurisdiction. Presumably, nothing has changed to encourage or discourage the Loan Markets Association in their selection of that dispute resolution forum. I suspect that the reason why there's been no push towards arbitration is also because in London there are various arbitral institutions like the LCIA. So it's difficult to say which one is, the most ideal. So the English courts look like a good choice and has been the safe choice for many, many years. In terms of the pros and cons of choosing arbitration in England versus the English courts jurisdiction. Well, I can certainly think of at least two advantages of choosing English arbitration over the English courts. It's just that one, if your defendant is not in the UK, then service is much more straightforward. If parties have agreed to arbitration, there's no need to apply for permission to serve out jurisdiction. And when you eventually do get an award, the award, as has been touched on today by the panelists, it would be much easier to obtain recognition and to enforce simply because of the New York Convention. But that said, I have to say that the English court, in my experience, has been very progressive in pushing through reform to the court procedure to make it much more streamlined, and has actually demonstrated great flexibility. They've pivoted very quickly in COVID to video hearings. My London colleagues said that the court was on Skype faster than they got onto Skype, which was very impressive. And actually, when OW Bunkers collapsed, they pushed through one of the very important decisions to the Supreme Court in about the space of a year. Is there one question? Hang on, so something pop up on my screen.
I think that's one for me.
Oh, all right. That one is for?
That's for me.
For Adelaide. Yeah.
Now, For case names are in with my beautiful Chinese accent, but there's a 2019 Shell, the 2020 Shell case is the abuse of dominance case, and Viscus is one of the parties in the most recent cartel case of December 2019. So I hope with that information you're able to locate the judgment. My contact details are on my presentation, so please don't hesitate to get in touch and I'll send them to you.
Thank you, Adelaide. Well, since we're on the topic of discussing the pros and cons of arbitration and versus the court, choosing the court route, how about a question for Edward, which is actually, I also read the Shagang and Daewoo decision with great interest, because we have certainly seen in the past, I think a lot of my clients, and I think Edward's clients, would think that if they agreed to arbitrate in Hong Kong, they had to apply English law. And if they chose to use English law, they had to arbitrate in London. But I've certainly seen an increasing openness by our clients to agree dispute resolution clauses in contracts where disputes are to be resolved by arbitration in Hong Kong with English law to apply. And I wonder if Edward has seen the same trend.
Thank you, Evangeline. It's a very good question. Actually, indeed, that I share the same thing with you. I think before 2015 or something, at least for my caseload, for the maritime arbitration, more than 90% is London arbitration. But now it's at least half or a bit less half that Hong Kong arbitration with English law to apply. I think the reason is because that more and more parties, especially with the Chinese flavor in that context, then they prefer to choose arbitration in Hong Kong because of the advantages to arbitrate in Hong Kong. I would say, for example, like today's panel, we can see that Hong Kong can offer a very diversified pool of lawyers, and not only for speaking the same language like English and Mandarin and Cantonese, but also especially if you have the Chinese parties in your arbitration, we share the same culture. So that is the other jurisdiction, most of the other jurisdictions cannot offer. And secondly, and most importantly, not to say that I briefly touch upon the enforceability of Hong Kong arbitral award in the rest of the world under the New York Convention, but also in mainland China. I think it's also because the interim measure that I only mentioned the name, that was an arrangement signed between the Supreme People's Court in China and also the Hong Kong Department of Justice last year. In 2019. Time flies. And I was actually the first Hong Kong lawyer who got the interim measure order from a Chinese court under this arrangement 8 days after the arrangement came into effect. And that's actually a breakthrough or milestone for Hong Kong arbitration, because under this arrangement, Hong Kong became the first and only jurisdiction outside of China, outside of mainland China, for the arbitration can apply the interim measures from the mainland court. Not the other jurisdictions, including all the famous arbitration venues in the world, can have this privilege. That means when you have arbitration in Hong Kong, and if the other side has any asset or the documents or conduct that you need to preserve, then now you can apply to the relevant Chinese court, the mainland court, for the preservation of the assets and the conduct and also the evidence. So that is definitely a turning point for Hong Kong, to gain the very advantaged status of. And also very briefly, talking about Evangeline, you mentioned about the question for the financial institutions, why they traditionally prefer to choose a court instead of arbitration. Of course, by tradition, I think is because most of the financing documents are domestic, and especially that the borrower normally provides a guarantee to the bank or to the financial institutions, which are very easily to be enforced. But now more and more, I see from the dissolution clause in the financial documents, arbitration is sometimes mentioned, especially for the cross-border dispute, for the cross-border lending. In Hong Kong, I recently gave a seminar to a Chinese financial institution based in Hong Kong. They asked me the same question, that why we should choose arbitration but not litigation. Very quick and simple answer is that if the other side, if the borrower is based in mainland China, then choose arbitration because you can easily start your legal action and then to enforce your arbitral award. But if it is litigation, then service out of jurisdiction is very complicated and time consuming. And also the enforceability is more complicated than arbitration. So thank you, Evangeline.
Thanks, Edward. I was actually discussing your question as the question with some of my finance colleagues, and as you know, we do have a very strong reputation in the finance world here. And I totally agree with you that we would give the same advice if we were advising a financial institution. As Edward has neatly summarized, there has been quite a lot of developments in terms of establishing mutual recognition arrangements, especially between Hong Kong and mainland China. And as Heidi has touched on, the mutual recognition assistance in bankruptcy proceedings between the two jurisdictions. And the reality is that I think the previous framework needed some work, and it's definitely been, and it doesn't look like Hong Kong or mainland China will be ratifying the ancestral model law and cross-border insolvency anytime soon. So this framework is actually very much in need, I would say, especially given the close business links between Hong Kong and mainland China. So I wonder if Heidi talked about Samson paper, but is there any move to, I think if I'm correct, the mutual framework would need to be ratified and become part of Hong Kong law. Are there any developments on that front?
I believe that Hong Kong is taking a step-by-step approach. The first step is that we need to implement the corporate rescue bill first. And then we are taking a step-by-step approach by first having the mutual recognition system and the cooperation mechanism. And then I think that will generally roll out more case law. And I do encourage every one of you to read that judgment and go to that judgment. In fact, in paragraph 14 of that judgment, the learned judge, Mr. Justice Harris, he has expressly mentioned that Shenzhen court, if they come to Hong Kong and with a letter of request, they will definitely receive positive reciprocal recognition and enforcement. And it is very interesting judgment. It's just an 11-page judgment, and in which you read it and you see that the court has appended a draft order in simplified Chinese characters with the equivalent English translation to set out the powers and functions of the liquidators. So this is very interesting to see a Chinese, style order drafted and appended in a Hong Kong court given by Mr. Justice Harris. This is very interesting.
Thank you, Heidi. That's very informative. I really do need to read the judgment. There is a question for, I think, to Karen, asking about how a Merivale injunction would work in case of ransomware attack and if a ransom is paid.
That's a very interesting question. Thank you. Actually, I don't know the answer to it. I've not come across a case like this before, but I would. If a ransom is paid, I think
if ransom is already paid.
It's already paid.
Then the Merivale injunction is no longer useful.
Yeah.
You need to trace.
Yeah.
Yeah, because the injunction is for the purpose of.
It's a preservation of assets.
Yes.
So basically, you wouldn't. Well, if there's a fraud committed and you know that you paid money into a certain account, say in Hong Kong, then the Merivale injunction is to preserve the assets. So And of course, you can apply additional orders like the banker's booked orders to find out and trace the assets. But if unless you know if it's due to an attack.
If the fraudster is stupid enough, and after you send the money to his bank account, but the money is still there, of course, Moreo injunction is useful, and you can inject the bank account and then apply to get the money back. But normally,
it would have gone
you not find the money still in the bank account. So what you need to do is to take money. Yeah.
Let me share a bit about my experience, because I have for banks a lot of times, and well, from what I was told by the banks and also the Commercial Crime Bureau police officers, they share that very often Hong Kong is the first point where they got ripped off the victims, and then in 2 hours the money will be gone. And then the first, you remember, where they will land. The first is probably Singapore, and then they will be wiped back to mainland China.
Right.
So it's very interesting.
Yeah.
So you need to be very quick. So I share with Karen's sharing that you must take very swift action.
Practical tips. First of all, to report to police. Okay. And secondly, I think before you make the application for Moreo injunction, I'm not sure if Karen and Heidi agree with me, to understand whether the money is still in the bank account that you sent, is to apply for the banker trust order instead of the Moreo injunction, because banker's trust order is much cheaper, and you can spend cheaper money by giving to lawyers, of course, and then to know whether the money is still in that bank account. And of course, if it's still in the bank account, you can apply to Moreo injunction, but not, then you would consider about tracing the money.
And also reporting to police, well, the JFIU, they will assist as well.
I was going to say.
For usually we would advise our client to, first of all, in any event, just report it to the police and JFIU. They have an online application form which can be done within 5 minutes. And then, but at the same time, we would consider whether there's any legal actions that can be taken. And we have to understand the situation, whether the money has gone swiftly.
And it's really easy to apply.
Yeah,
it's really easy to make the application. I understand it's all online now. You don't need a lawyer.
Yes. Actually, you can report this yourself. Yeah.
Well, that was a really interesting question, and got us all quite excited. I think we have time for maybe 2 more questions. I think on a higher level, I thought I think what today has demonstrated is how you cannot practice law in isolation anymore. There's so much, there's so many in what we do as businesses cross borders. It's inevitable that we have to figure out how to operate in different legal systems and understand how different legal systems interact. So perhaps the best person to answer this question is Adelaide, having practiced in London and Brussels and now in Hong Kong. And I wonder, if she could share if her multi-jurisdictional experience has been useful in enabling her to provide a better service to her clients, and whether she can share some examples with us, of course, on a confidential basis, if she's talking about her cases.
Sure, of course. Thanks, Evangeline. I mean, look, the answer to that is without a doubt, it's definitely been very useful for me. I think I'm a bit lucky. Competition law is one of those areas where the principles, the concepts are very similar across jurisdictions, and actually they're converging more and more as new regimes come online, as competition laws are refreshed and renewed. So I think it's natural for the newer regimes to look to other regimes who've perhaps thought about particular issues before, and that have really considered and published thoughtful judgments and decisions on the same issues, because that will then help us interpret or guess or predict how a local regulator might approach a particular issue. It really helps to frame the issues. In Hong Kong, of course, we're really just getting started with competition law. But we're quite lucky because the competition law is very closely modelled on that in the EU and that in the UK. And you only have to really look at some of the judgments that have come out here in Hong Kong from the Competition Tribunal to see the judgments dotted with references to case law from the UK, to case law even from Australia, from the US. So really having a broader perspective and having lived and breathed it somewhere else, I think has been incredibly useful. And it's not just for Hong Kong, actually. Southeast Asia and even China has a much newer regime compared with those in Europe. And so where there are gaps in local precedent, I think it's natural for us to cast our eyes around and see whether somebody else has considered it previously and apply it here.
Thanks, Adelaide. I wonder if we should I just wrap it up? I think we've just got a couple more minutes anyway, and then we can move on to the next panel. So I think it's, once again, thank you to all four of you for your presentations. I think I'm sure that the attendees learned a lot, and thanks again to the Law Society of Hong Kong and the Law Society of England and Wales to give us this opportunity today to share our experiences across jurisdictions, and also to be able to show that law cannot be practiced in isolation anymore. I'm not a big fan of exams, but certainly I think that if getting another qualification, that means you have to do an exam so that you can better provide a better service to your clients, then by all means.
Thank you very much, Evangeline. And thank you very much to our panelists for the very interesting discussion. So we have a short break now, and we will reconvene at 20 past for the second panel discussion. So thank you very much.
Good morning and good evening. President of the Law Society of Hong Kong, Melissa Pang, President of the Law Society of England and Wales, I, Stephanie Boyce, distinguished guests, moderators, and panelists. My name is Lisette Robleto de Haworth. I'm the Law Society of England and Wales International Programs Manager. I lead on the International Women in Law programs, along other programs. I am delighted to be moderating this session today, and I am absolutely extremely pleased to be surrounded by such a fantastic array of panelists for this session. Overcoming the barriers that prevent women from entering and progressing in law is an imperative for the future of the profession. However, the legal sector will not be able to provide suitable and sustainable responses to gender inequality without first having a deep understanding of the global barriers that limit the career progression of female lawyers. Political will and strong commitment from all relevant stakeholders, including firms, businesses, clients, bar associations, and law societies, are also essential components to success. To begin with, obtaining the necessary quantitative and qualitative data is critical. For that reason, between November 2017 and January 2018, the Law Society undertook the largest quantitative global survey on women in law with over 7,000 respondents from across the globe, with the support from the International Bar Association and LexisNexis. This data was complemented with qualitative data gathered in the form of roundtables that took place between July 2018 and April 2019 from 34 international roundtables held in 21 cities across 18 countries and with the participation of over 700 female lawyers. The finding of this report, entitled Advocating for Change, Transforming the Future of the Legal Profession, state, and I'm just sort of putting the link to the report on the chat. The report stated that 52% of respondees said that unconscious and conscious bias remained the main barrier to women's career progression in law. Bias and stereotypes are expressed through social and cultural expectations about how a woman should behave on account of their gender. 49 responded to unacceptable work-life balance as the second top reason that prevents women from progressing and reaching senior levels. 91% responded that a flexible working culture is critical to improving diversity in the legal profession. And yet, flexible working still has a stigma attached to it, and in some jurisdictions is not an available option for many lawyers, despite the technological progress and the numerous benefits to businesses and employees. 60% of 6,500 individuals responded that they were aware of gender pay gap within their organizations. But unlike their male colleagues, female lawyers are often challenged by their clients and employers about the level of fees they charge and request reductions on account of their gender. What is very striking about the findings of the report is that the legal profession in all different jurisdictions need qualitative and quantitative data to ensure that we continue building the business case for women in the profession. For the legal profession in Hong Kong, the proportion of women varies at different stages of their career path in a law firm. Data as of 17th of November 2016 states that women made up of over 60% of trainee solicitors, but less than 30% of partners. This pattern of gender participation repeated itself with little change over the past decade. The female trainee to female partner ratios were 67% to 22%, and 60% to 21% in 2005 and 2015, respectively. This means that while more than half of the new entrants to the profession are female, only less than 1/3 are at the senior level in their institutions. These figures also raise questions about the retention and advancement of women in the profession. It is in this context that both the Law Society of England and Wales and the Law Society of Hong Kong joined forces to discuss the challenges and solutions to gender inequality for women in law. I am joined by a very distinguished set of panelists. Each panelist will speak for 5 to 7 minutes, and I will be posing some questions. We will end with some question and answers from the floor. So please put your question on the chat as we go along. I am delighted to welcome our first panelist. Our first panelist is Olivia Kong. Olivia is one of the founder partners of Wellington Legal. She's an experienced litigator solicitor who has worked in the United Kingdom and Hong Kong. She's a fellow member of the Hong Kong Institute of Arbitrators, has acted as counsel in arbitration. She was appointed as an arbitrator of Guangzhou Arbitration Commission in September 2020. Olivia holds an LLB in law from Queen Mary University of London and completed her legal practice course from the University of Exeter. She qualified as a solicitor of England and Wales in 2003 and Hong Kong in 2012. Prior to establishing Wellington Legal, Olivia worked for several top-tier firms in the UK, a leading local firm in Hong Kong, and has in-house counsel for a listed financial company. She's the chair of the Women Business Lawyers of the Inter-Pacific Bar Association and committee member of the Law Society of Hong Kong Standing Committee of External Affairs. Olivia, thank you for joining us today as a panelist. I'm delighted to see you here. From your perspective as a single mom and starting your own firm, could you please share with us the challenges and opportunities you have encountered as a lawyer? Thank you.
Thank you, Lizette. Before I answer your question, I would like to actually go into the survey by the Law Society of Hong Kong in 2019 in more detail, because we have actually listened to the figures, but I have actually taken the liberty to read the whole survey results, and I have summarized in a few slides so that you guys can actually see what's happening. Because what I noticed is there's actually some, you can actually, from the results, you can actually see what's actually going on that causes this problem. Now, the first statistics, okay? So if we move on to the next slide, is the earnings and positions, which we all know. Male respondents generally earn more than female respondents. About 12.7% of male respondents earned 4 million Hong Kong dollars or above, compared to only 4.3% of female respondents with the same range of earnings. More than half of the new entrants to the professions are female, but only 1/3 at senior level. And as of June 2021, women in private practice made up of 65% of trainee solicitors, whereas they only come up to 30% as partners. If you move on to the next slide for me. Yeah, so wait, give me a second. Okay, discrimination in workplace. Now, this is actually quite an interesting question. They have asked in a survey, 82.4% of the respondents said that they had not actually experienced any discrimination in workplace. And when it comes to, next slide, sexual discrimination in workplace, could you move? Yeah, 97.1% said they had not experienced any sexual discrimination. And this is quite interesting. Now, if we move on to the next slide for me, thanks. Working hours. Now, when they asked the survey, asked for the working hours, 50.5% of respondents said that they had to work more than 45 hours per week, and 6.2% had to work more than 60 hours per week. Could you move on to the next slide? Yeah. Now, work-life balance. The survey actually asked the respondents whether they can indicate what working arrangements could help them to achieve a better work-life balance. 75.9% of respondents chose flexible working hours, but only 44.1% indicate that such arrangement was available in their current workplace. 57.9% chose remote virtual office or home office, but only 37.9% has such arrangement available in their current work environment. 36.3% of respondents revealed that, in fact, no working arrangements whatsoever were present in their current job. Next slide, please. So the survey also asked people why you leave the legal profession or private practice. And it comes up with the top reason to leave the legal profession was influenced with family planning or family life. And the main reason respondents prefer to work in other sectors, although performing illegal functions, i.e. outside private practice, because they found it difficult to maintain a work-life balance in private practice. And 57.7% said they found too much billing pressure in private practice. Next slide, please. Dependence. This is something no one seems to have mentioned. 62.2% of respondents indicated that they had dependents. And of those, 53.1% were primary carers, and 72.4% of the primary carers are actually females. Next slide, please. Okay, so anyways, why am I showing you all these figures? What for? What does it indicate? The indication, in my view, it's the reason why we're having problem with females climbing up the ladder is because of the time restraints. It's long working hours, lack of flexible or remote working arrangement in law firms, and the fact that they're main carers in the household. And that's a reason which frankly puts a lot of women off to pursue the career in law. So what's this to do with single parents? For those who are not really familiar what single parents are, I just give you a definition. Single parents are defined as mothers or fathers who are never married, widowed, divorced or separated, with a child or children aged under 18 years old living with them in the same household. According to the Hong Kong 2016 census, the majority, 74.7% of single parents are aged between 30 to 49 years old, and single mothers actually occupy 80% of the single parents population. And obviously, I don't think I need to explain too much. Divorce rates on the rise because of the way life is. Lots of people are getting divorced. So as a result, there are more and more single parents, and especially in the legal profession. And I think this is something not many people have raised before. We talk about LGBT, we talk about women inequality, etc. But one group of people which seems to be ignored. It's the single parents. And this group of people, in fact, is growing quite rapidly. For example, my son, he's actually, I'm a single parent myself. My son, I actually mentioned to his teacher last year that my son feels a bit awkward that his parents are not living together, as my ex actually lives in the UK. And the teacher actually said, oh, don't worry, it's not only your son, it's half of the class, the parents are already divorced. In fact, I'm divorced too. So it actually shows reality is that there are more and more people actually going into this group of people. And the obstacles for single parents is they have difficulty in juggling work and childcare. And also they have financial burden because some of them, not everyone has got money from the other partners or ex. Also, there's social and stigma from the society. For example, in Hong Kong, because we're still a quite traditional city, and it's the Chinese way of thinking that it's best not to disclose the fact that you're a single parent. So lots of people, they do not mention that they are single parents, but in fact, they are. Also, obviously, as a result of the difficulty in juggling work and childcare, they also encounter another problem is that they find it difficult to find someone new. But that one we won't be able to help them, unfortunately. So we'll concentrate on things we can do. And also, alongside is the impact of children from single parents family. They also have difficulty at school in terms of they feel a bit, how to say, outsider or kind of, why is everyone else's parents live together but mine's not? So these are things that will pop up. Now, as a chair of the IPBA, Women Business Lawyers Committee, I actually arranged a talk, a session in 2018. The title is Silent Struggles of Single Parents, the roles of law, employers, and societies in supporting them to succeed in their public and private lives. We had actually got speakers from different jurisdictions, including myself from Hong Kong, India, France, UK, New Zealand, and the Philippines. We actually exchanged views on the cultural perspective, law perspective, and also the perspective from the society. And we find that is actually quite interesting because we find that some countries seems to have a more advanced legal system in terms of dealing with single parents, and they seems to feel more accepted in some societies than others. For example, in the Philippines, actually one of the speakers have actually raised the fact that in the Philippines, there are actually laws to help single parents. I have actually asked one of my good friend from the Philippines, she is a lawyer in Hong Kong, Eunice Tan. She actually summarized the law for me, and it's called the Solo Parents Welfare Act of 2000. And it's basically entitled to flexible work schedule, non-discrimination at work, and parental leave benefits for those single parents. And apparently there is a proposed amendment to the Solo Parents Welfare Act, and it's currently a House bill going to pass. The amendments to the act is further enhancing the benefits of single parents, including provides qualified solo parents for additional benefits of 10% discounts from purchase of basic necessities of a child or children under the sole responsibility of the parent, or enhance the educational benefits provided under the current law by guaranteeing full scholarship for a child of the solo parent and prioritizing the other children, if any, in the education programs of the government. Promotes childminding centers, breastfeedings in the workplace, and social safety assistance to all kinds of solo parents and their children. And also provides for employment programs for single parents by prioritizing them in the livelihood, training, and poverty alleviation programs of the government. Also medical and health welfare given to solo parents as well, by giving them priority in government hospitals and medical facilities. Also in France, one of the lawyers mentioned to me before that they have actually got, it's actually quite common for single parents in France now. And that's why their law is also quite advanced in this respect. Now in Hong Kong, what we are not that advanced in terms of law for single parents. I mean, as a single parent, you get allowance for tax, but not much more, to be honest. But what we can do, I mean, apart from changing the law or trying to encourage law firms to do something, I think the first thing is how to get these single parents back into the workforce, or at least encourage them to continue with private practice, is by encouraging flexibility in the workplace. For example, flexible working hours, work from home, etc. These things are also applicable to generally the female gender problem. Yes,
Olivia. Yeah, your time is up.
I'm so sorry, but yes, that's what I think, and also raise global awareness as well. So yes, that's what I want to say. Yeah, thank you.
Thank you very much for such a comprehensive presentation, Olivia. And I have noted some of your excellent case studies from different jurisdictions about how to use those best practices to integrate them into the Hong Kong reality. I now pass to our second panelist. I'm delighted to introduce Deborah Fong. Deborah is Vice President of Investment Management at Morgan Stanley in Hong Kong. She has acted as legal advisor to a range of investment funds in private equity, real estate, and infrastructure projects. She has also advised on the marketing of private investment funds to various jurisdictions, as well as internal control matters. Deborah has an LLB law from King's College London, a postgraduate certificate in law from the University of Hong Kong, and is a practicing solicitor in Hong Kong. She's also a committee member of the International Legal Affairs Committee of the Law Society of Hong Kong. Welcome, Deborah. Great to see you here. From your first perspective as a working mother, what challenges and opportunities have you faced as a lawyer? Thank you.
Thank you very much for your introduction, Lisette. And Olivia has just been very helpful in talking about all these statistics. So maybe I can do a bit more sharing from a personal perspective. So yeah, as Lisette mentioned, I'm a working mother. I have 2 children at home, 1 2-year-old and 1 1-year-old. So yeah, typical working mother. So I gave birth to my first kid in 2019. And at that time, I was actually already on the list of promotion candidates in Morgan Stanley. So when I found out about my pregnancy, I was really worried. I was wondering, oh, would that affect my promotion chance, etc. But at that time, like even before I raised it to my supervisor, the management in Morgan Stanley came talk to me. And they told me that, oh, we are so happy that you are pregnant and don't worry about your promotion. It wouldn't affect you at all. And that they had no idea how much that meant to me, like hearing that from them. And it helped me so much, like because I was so anxious about like my job prospect and within the bank. And it's just so nice to hear that from my supervisor. So I think like if you guys are any one of our attendants here, like if you have a managerial role in your firm, I would highly recommend you to say more this kind of like warm statements to your female colleagues, and it really helped. And you have no idea how much that meant to that lady. So after I gave birth to my son, I got back to my job, and yeah, I successfully got promoted. I think it meant a lot to me, like not just to me actually. It also meant a lot, I believe, like to my other female colleagues who's thinking about starting a family or even getting pregnant and have babies. And at that time, like now looking back, I think there are a few key points about my at least like based on my experience. Like first of all, like when I was away on maternity leave, my firm actually arranged someone to be my maternity coverage. Well, it may not seem very important, but actually it means it is important because that means my absence from work wouldn't affect too much about affect my colleagues too much. Imagine if my firm didn't spend the money to hire a maternity coverage for me, that means my colleagues will have to take up my job and their workload would be increased. And certainly that would affect the morale and the atmosphere in the office. No one would want to do 30% more work for nothing extra, right? So I think that is very helpful. And also, as I mentioned, I think the supportive words and affirmative recognition from supervisors really mean a lot. So yeah, that is some of my sharing about my journey of giving, being pregnant and giving birth. And maybe I can talk a bit more about, as a working mother after I'm back from maternity leave. I think a lot of people have some sort of misconception and they think that, oh, she's a mother, she probably doesn't care that much about career progression. Probably those working mothers just want to get off work on time and see their babies. Well, as much as I would like to see my babies after work, I care about my job, well, a lot less than my babies. And I think it is this kind of bias or unconscious bias that people need to be very careful about. I think one thing is it's not just about the role of working mother. Actually, working father is also a role, right? So many people just assume that mothers would need to spend a lot of time taking care of their babies, but actually my husband spent a lot of time with my kids as well. So I think it is important to realize that actually both male and female, both sexes have important roles in the family, and any organizations, whether a law firm or banks, they should really recognize it. And I think nowadays more and more firms are giving paternity leave. I think that is a good start. So at least from a policy perspective, it starts to recognize that fathers have an equally important roles as mothers at home. And I think that is a very good start. But obviously, I think more needs to be done in this area. Like as Olivia just now mentioned, just like flexible workings, working from home arrangement. I think all these are important. So yeah, that is my sharing. I'm not sure how many minutes I have I have left. But stop me if I'm running out of time.
You have 30 seconds to go. So
okay. 30 seconds. Well, I think just to wrap up, I think in terms of again, I think supporting for female have to go hand in hand with supporting for male, because without giving male more flexibility to handle family work, the female cannot be, basically cannot be free from all these obligations, and I think it's important to recognize that. So yeah, I can go on and talk about my experience in Morgan Stanley more, but unfortunately I'm running out of time. So happy to share more if we have time left at the end of this session.
Thank you, Deborah. And I think you have highlighted a fantastic and an important point, which is the leadership of institutions and the support from institutions is key in keeping their staff not only motivated, but also their anxiety and stress is reduced, because obviously you have the peace of mind that just because you became a mother, it doesn't mean that your prospects in your career will be affected as a result. And also the second important point that you made that I did notice is that sharing parental responsibility, so that the burden falls on both female and men, but also that means translating the same level of support to both men and women. So thank you very much for sharing that.
Thank you, my pleasure.
Thank you. I now pass to our third panelist, Ronald Sum. Ronald is a partner, commercial litigation at Adelshore and Goddard. He's qualified as a solicitor in Hong Kong, England, and Wales and Australia. He's a fellow member of the Hong Kong Institute of Arbitrators and a fellow member of the Chartered Institute of Arbitrators. He's the immediate past chairman of the International Chamber of Commerce, Arbitration and ADR Subcommittee. He's also the council member of the Hong Kong International Arbitration Center. Ronald has recently been appointed as an investor state mediator under the Mainland of Hong Kong Closer Economic Partnership. He sits on the Hong Kong Government Advisory Committee on the Promotion of Arbitration and the Hong Kong Steering Committee of Mediation. He's a member of and chairman of the Public Education and Publicity Subcommittee, and he's also a member of the Law Society of England and Wales China Women in Law Core Group. Ronald, it's great to see you here. And as a male champion for change, what experiences can you share with us about the challenges and opportunities you have seen women experience as lawyers? Thank you.
Everyone may be asking, why is this male champion sitting here talking about women in law? Well, it happens to be that I am the recruitment partner of my firm and in previous firms. I actually invented the recruitment system in one of the firms, which is now a rather massive firm in Hong Kong. Now, probably you haven't seen, you can probably only see me on the screen, but on my left, we have 3 interns, okay, just happens to starting the internship in my firm. One is from Hong Kong U, one is from City U, and one is from Chinese U. Unofficial statistics, let's put it this way. According to the Hong Kong U intern, over 2/3 of his classmates are of the female gender. City U, around 80% are female potential lawyers. Chinese U, in the JD section, 90% of her classmates are of the female gender. So there you go. In the next batch of trainees application, I'm certain that you'll see lots of ladies applicants there. Now, when I first did the recruitment process, when I first started some time ago, nearly over 20 years ago, I have received these questions, and these questions have been around for some time. Well, your recruitment department from your head office, be it in US, in UK, or wherever, will say, well, let's judge a candidate, okay, by testing them. Give them written tests, give them oral tests, interview them, okay, and then you have a score sheets. Now, experience told me that ladies probably study better than the male students. So they usually come out better than in scores than the male students. That's not an official statistics, but my experience. Now, immediate question is, well, hold on, we are recruiting 4, 5, 6 trainees. They're all females. Okay, well, in my job, I can't have female applicants. Okay, in certain of the industries, I must have male trainees to do the work. So are we foregoing the better female students for male students? Okay, so that's always been the $1 million question. Now, obviously, time has moved on. This question has arisen a number of times, and I've been thinking that for a long time. Now, my understanding, okay, that the question now is actually not how well a female student does better than the male students, or male students do better than the female students. It's actually how should there be a difference? I think nowadays everyone is more alert to whether to gender equality. Take the example. As Lisette has pointed out, I sit on the HKIC Council members, and I'm also the Appointments Committee member. Now, using that as a particular example, there have always been discussions, okay, amongst the members of the Appointments Committee. Then there are male and female there, okay, as to whether we should appoint a male chair or male arbitrator or female arbitrators, or there should be a mix. I think this should be a conscious approach. Okay, there should not be any inequality between them. In fact, having over 25 years of experience practicing law, I think the female, I think many of the senior management now believes that the female gender, the female lawyers actually brings in a different perspective. They are more alert to the situation. Now, so at many of the firms, okay, whilst there still need to be a conscious approach to this male and female or female inequalities. The bottom line is that many of them still talks about, well, if I hire female juniors, well, they're married someday, they may have maternity leaves, etc. Many of the firms, as far as I know, including my firm, has, I'm not selling for my firm, let's start with that, has a good maternity leave a scheme. I mean, nearly 9 months off for the 9 months for the maternity leave for the new mothers. Okay, and to be honest, our senior management thinks that, well, if there is a need to hire someone to replace her during her maternity leave, so be it. I think, as Deborah says, this is something in our many senior management believes is good. Okay. Now, and of course, in many of my colleagues have been asking, well, in law firms, it's so difficult to book a conference rooms because everyone requires a conference rooms. Well, many of the senior partners I've talked to, they actually told me that, well, if you give up a room for breastfeeding, so be it. Okay, it doesn't have to be a big room, a small room. It doesn't affect a lot of things. Now, these are all conscious things that a law firm can do. Now, have we reached a stage that we are doing this unconsciously? No, I don't think so. Okay, but certainly the situation is that many of the firms or many of the friends I talk to in senior management role have taken a conscious approach to this topic. And at least in Hong Kong, I have not heard of a firm or have my friends saying that, well, because of certain aspects, in particular for those practicing lawyers, billing targets, etc. Because of billing targets, because of profitability, we are not going to hire a female junior or a female lawyer, just in the event that she gets married or decided not to come back and spend the time in training them. Now, to end, yeah, to quickly end, with give me 15 seconds more. I think the situation of working from home, especially in this pandemic times, have actually helped the inequality here, because nowadays many can actually work from home. I don't think any one of the participants here have not worked from home or will work from home. So we are doing this online. Okay, I think it is rather common to do things online now. So that is another improvements, I suppose, unconsciously. Okay, and improvements in having an equality for women in law because they can work from home and take care of the kids or whatever. So everything is going towards the right direction. That's my take on this topic. Sorry to be slightly overrun on this.
Thank you, Ronald. I think your contributions were really spot on in the sense that you highlighted the significance of recruitment in terms of increasing gender equality. And in fact, there have been some other jurisdictions providing very good best practices in terms of blind recruitment in order to ensure that there is a sort of a meritocracy rather than an unconscious bias or conscious bias appearing or raising its ugly head when doing the recruitment. And thank you for sharing the fact that in spite of the progress being made, there is the need to continuously break those gender stereotypes that still remain within the profession that prevents women from being even seen because they could be potentially be mothers. And thank you for reiterating that point that a conscious effort needs to be made in order to break down those barriers. And finally, thank you for sort of highlighting the role of the pandemic on the generalization of flexible working during this period. And this is, as you rightly said, is a gain that has benefited both women and men. And of course, it is proven to be something that it is doable within the legal sector, especially given the rise of technology today. And it would be even more beneficial for both men and women if both share that responsibility in their household, so that it is not that repetition of the double burden as a result of the flexible working. Thank you very much, Ronald, for that. Last but not least, I would like to present our final panelist, Brooke Holden. Brooke is a principal at Caras LLP. She's a dispute resolution specialist with experience representing clients in a broad range of complex and cross-border commercial disputes. Her areas of expertise include advising on claims arising from large corporate collapses, multi-jurisdictional fraud, and assets recovery. Her experience includes handling dispute resolved through litigation, arbitration, and other forms of alternative dispute resolution. Brooke is admitted as a solicitor in Hong Kong, Queensland, Australia, and England and Wales, and holds an LLB and a BA in Asian and International Studies. Brooke is a co-chair of the Women in Law Hong Kong, having served on the committee since its inception in 2015. She has lived and worked in Hong Kong for over 15 years, having relocated from Brisbane, Australia in 2005. Brooke was also a contributor to the Law Society of England and Wales Practical Toolkit for Women in Law, a report that was launched in March 2021. She's also a member of the Law Societies of England and Wales, China Women in Law Core Group. And just for further information, I'm going to be pinning the practical toolkit on the chat so that you are able to access it. Brooke, it's so great to see you today. Thank you for being here with us and for sharing your experiences. Has contributed to the recent Law Society's report, Practical Toolkit for Women in Law, and in your experience, are women lawyers breaking the glass ceiling, and what can we do to retain talent? Thank you.
Thanks, Lizette. First of all, let me say how grateful I am to both law societies for placing this issue on the agenda and for giving me the opportunity to share my thoughts and experiences on a topic that I'm very passionate about. Usually in seminars such as this, we're preaching to the converted. A bonus of today's webinar is that there are hopefully some attendees who were interested in the first session who remain aligned in need of their 2 CPD points, which gives us an opportunity to share more broadly. It is an ambitious topic to cover in 1 hour. The challenges we face as an industry in achieving gender parity can only briefly be touched upon in the allocated time. And to suggest that we found a solution is unfortunately far from reality. That said, the fact that we're having this dialogue, that law societies across jurisdictions are joining forces to explore solutions, that stakeholders are devoting significant resources to diversity and inclusion, and that support networks such as the Women's Foundation and Women in Law Hong Kong exist is encouraging. I'm not going to spend time today talking about the why. It's implicit in the fact that we're talking about solutions to gender inequality, that we're at a stage in the journey where enough of us are convinced that equality should be the goal. That by the time my two daughters, who are currently aged 4 and 8, enter the workforce, we won't still be having these same conversations. As for the how, I want to start by sharing a personal story. I remember a couple of years ago when my son was 8, we were discussing some classroom antics, and I asked him to describe a boy he was talking about. I was looking for context to a particular comment that he made, and I asked a couple of leading questions to try and identify which classmate he was referring to. Is he English? Is he Chinese? Is he Indian? What do you mean, Mummy? He looked at me really puzzled. Do you mean, does he have black hair? It dawned on me that at his age, at 8, he didn't see race, gender, ethnicity, hair colour, body type, or any other attribute as an identifier, let alone something that would ultimately act as a barrier to that person reaching their full potential. It just didn't occur to him. So where are we going wrong? Where are these preconceived ideas of inequality entering our children's minds and ultimately creating the barriers that society is having to invest heavily in to break down and resolve? Focusing on the legal industry, where are we on the journey? What does female representation look like across our industry? And to answer your question, Lizette, is there a glass ceiling? Unfortunately, statistics which have been shared helpfully by Olivia earlier today will tell us that there is. Within the solicitor profession, despite the fact that 60% of all trainees registered with the Law Society of Women and 50% of legal professionals in law firms are female, we make up about 30% at the partnership level. At the bar, a similar story can be seen. 60% of junior barristers are female, yet women only represent a total of 30% of the bar list. Hong Kong isn't unique, however. We heard from Stephanie at the outset that the UK statistics are similar, and they are in Australia too. What these figures tell us is that something is happening along the way to prevent or hinder women making it from the top. This situation is, however, improving. Over the past few years, we've seen more and more females appointed to senior positions within the legal industry. We have a female president of the Law Society, who you heard from earlier today. Our Secretary for Justice is female. We've appointed 2 female judges to the Court of Final Appeal. We have recent female appointments to senior counsel and the bench, and we're seeing an increasing number of female managing partners. When I had my first child 10 years ago, I was openly asked by a partner in my firm whether I really wanted to return to work at the end of my maternity leave. Wouldn't I rather stay home to care for and spend time with my child? While well-intentioned, I can guarantee you that my husband was not asked the same question when he returned from his then 2 days of paternity leave. I knew I had an uphill battle ahead of me. Thankfully, I doubt this question would be asked today. As we learn more and more about the complex challenges that are affecting women's progression and representation at senior levels within the legal industry, the better we're able to understand and address those barriers. I do say we, because it isn't just a women's issue, and gender equality won't be achieved by women alone. As Stephanie touched upon briefly at the outset, and as each of the panelists have just shared, there are a variety of factors holding inequality in place: conscious and unconscious bias, gender pay gap, outdated working practices and billing models, bullying and sexual harassment in the workplace. As for solutions, a holistic approach is necessary. Fundamentally, dialogue and communication is key. It's key to unearthing the challenges that women are facing as they progress their legal career, and it's certainly key to finding solutions. Once the barriers are identified, we can seek to address them. We shouldn't be afraid to ask the hard questions. Why are there less female partners than males in Hong Kong? Why should I choose a woman to lead a team when I know that motherhood is in her short-term future? Why should I promote a female colleague who is about to go on maternity leave? How should an extended maternity leave period affect a woman's PQE level, promotion prospects, and pay grade? How does my biological clock affect my career progression? Why are female lawyers perceived to be less easy to work with, and female partners less popular than male partners? Are my male counterparts being paid more than me? Understanding the global barriers limiting career progression of women in the legal sector is a significant step for addressing gender inequality. When we know better, we do better. In 2019 UK Law Society report on gender equality in the legal profession, which Stephanie touched upon earlier today, a number of recommendations were posed which resonate in the Hong Kong context. The role of men as champions for change, zero tolerance for sexual harassment, targets and quotas, value-based business and development, recruitment and selection processes, and two topics really close to my heart: women supporting other women and leading from the top and by example. Following the 2019 report, earlier this year, as Lizette mentioned, the UK Law Society published a practical toolkit for women in law. The report recognises the effectiveness of support networks such as WILC and TWF in moving the dial on gender equality. WILC was established almost 6 years ago by a handful of leading Hong Kong firms wanting to progress the diversity and inclusion agenda within the legal profession. Today, I'm happy to report that we have over 1,400 members across private practice, in-house and across functions. We have a working committee divided into 7 work streams and a heavy-hitting advisory board made up of senior professionals within the industry. We focus our initiatives on supporting and empowering women within the legal profession to achieve their career aspirations whilst maintaining their wellbeing. As the 2019 report and the toolkit highlight, support networks are a critical component to achieving transformative change within the legal industry. Coaching, mentoring and sponsorship are also incredibly important and powerful. Key players should commit to raising women's reputation and profile so that the work undertaken by them is as visible as their male counterparts. Having support and guidance from someone in a more senior position as you move through key stages of your career can really help focus your mind on what goals and ambitions you have and how you're going to achieve them. As you can probably tell, I could talk on this topic all day. I've touched on some of the major challenges and hopefully have provided some food for thought in terms of solutions. I'll hand back to Lizette now.
Thank you, Brooke. And thank you for posing those very reflective questions, because as you rightly said, dealing with gender inequality in the legal sector or even beyond is very complex and it is not required to have just one sort of full solution. It's actually a multiplicity of solutions that are required in order to continuously position this topic and this agenda forward. And thank you for highlighting the fact that statistics actually stress or emphasize that there is a glass ceiling that needs to be broken. And the fact that there is, that although that there is, the situation is still very difficult, we see some glimpses of progress in terms of women achieving positions of leadership, but more needs to be done. And some of your solutions are really spot on as well. Thank you very much. Supporting networks, coaching and mentoring that has some training opportunities have been highlighted in many jurisdictions as well. In the last 7 minutes, because I need 1 minute to wrap up, I would like to sort of pose some questions to all the panel. The first question is, what is the role of law societies and bar associations on this area? And I leave it there, and if you could be brief and if you could give me your answers, that would be absolutely fantastic. Thank you. Brooke, can we start with you?
Yes, sure, Lizette. I think Olivia and Deborah, who sit on the Hong Kong Law Society committees, might be able to give some more context, specific answers to this question. But from my perspective, law societies and bar associations are perfectly placed to encourage their members to adopt and implement policies that tackle gender inequality, address unconscious and conscious bias, and promote flexible working and improve work-life balances. We need law societies and bar associations to kickstart discussions on challenges and changes in the industry. As the organisations leading the profession, they have a large role to play in how the profession is structured.
Thank you. Thank you, Brooke. Olivia, shall we pass on to you?
I actually sit on the external affairs, but I'm not actually on council, so I don't get the decision-making choice. So I have actually, I look at one of the questions actually posted by the audience, asking what the Law Society do and what I think of doing. Actually, after looking at the survey results, I went for election. I went for election last year. To ask for change of actually encouraging more females, etc., and helping the SMEs. But unfortunately, I didn't get to win, so I cannot do this. Otherwise, I would have changed. I think, joking aside, I think because from my understanding of the statistics, it's mainly time is the issue. And women are basically struggling between juggling family life and work life. Now, if we can actually encourage more law firms to allow flexible working hours, because I know that there are still a lot of law firms, the smaller ones, are having difficulty of this, because especially with junior lawyers, they think that junior lawyers, they need a lot of supervisions. So they need to be physically there to teach them all the time, to hold hands with them. So that's why they are quite reluctant, to be honest with you, to actually allow junior lawyers to have the flexibility. Consultants, partners, yes, they don't care as long as you bill. But junior lawyers, especially associates, are the ones that are having the difficulty of really long working hours. And that's, to be honest with you, that's the time when most females actually have kids. So I think that is the part where we need to work on, especially trainees. I noticed some of the trainees, once they finish qualified, admitted, they immediately want to go in-house. So I thought, hold a second, in-house, you should be like at least like 5 years PQE, you should have done something in private practice before you go in-house. But they already said they don't want the working hours, they don't want the billing pressure. So I think this is the major thing we need to work on, how to change the way we bill, or how to change the way we work, apart from like video conferencing and stuff like that. In terms of paperwork, I think because, for example, litigation, we have got a lot of files. So how can you ask people to bring all the files home to do it? So these are the things we need to work on to help women to get back into the workforce. For example, my own law firm, we actually allow all these consultants to work flexible working hours. So that's why a lot of women with kids want to come and join us. But again, associates is the difficult challenge part. So this is the part I think we need a lot of like Law Society, not only Hong Kong, but UK or even other jurisdictions to sit down and work together and come up with some creative way to how to make law firms do this. Might maybe encourage them to do it or things like that. Yeah, that's my thinking.
Thank you, Olivia. Deborah?
Yeah, I know that we are running out of time, but I will try to keep it short. I think in terms of encouraging female to stay within the profession, it's not just a number of, oh, how many female partners in certain firms and what is the percentage of female lawyers. It's not just a number. It's actually a long journey with a lot of struggles along the way. And all these are very real issues which require every day's commitment. From a Law Society's perspective, I think transparency is really the key. Like, I think Law Society what Law Society can do is not only education and encouraging all these law firms to acquire female-friendly policies, but also to tell them, oh, what the other law firms are doing. And like, for example, in terms of maternity leave, it's such a wide discrepancy. Like my previous firm, Linklaters, is offering, I think, over 25 weeks. Whereas some law firms are offering 14 weeks, it's such a wide discrepancy, and it shouldn't be like that. I think that there should be, I'm not saying that every firm would need to acquire the same policies, but I think some sort of transparency and coordination in the industry would be very helpful. And that is the job of Law Society.
Thank you, Deborah. Ronald, in 1 minute.
Education. Education in not only telling people what other firms are doing, teaching them what to do. For example, using the maternity leave. Well, should it, doing a pay rise, should it be calculated on average, okay, the past 2 years, billings rather than excluding the maternity leave year. For example, telling the firms establishers, telling the people what other firms do. For example, in my firm, I'm glad to say that it's 52 weeks maternity leave, I must say, which is actually very good. For smaller firms, okay, unlike the bigger firms, they, as Olivia just says, well, in litigation, there are lots of documents. Tell them, okay, show them whether they can cloud the documents. Well, they're not big firms. They don't have any servers. Maybe the Law Society can take the lead, okay, and tell them, well, is it which cloud service is good? How do they teach them step by step, 101 to clouding documents, okay, so that they know what to do. So rather than think about well, what are, not only talking about what the firms are doing, show them the step-by-step guide as to how this can be done, and let them adapt to whatever ways they want to in promoting equality in women in law. It is, as I said, right at this second, it is we need to educate the people that this is a conscious issue. Okay, hopefully one day this becomes an unconscious issue. But right at this minute, okay, to educate them, this is a conscious issue. Bring them to the bring these issues to their mind. That's what I thought.
Thank you, Ronald. Well, we have reached that time. I'm sure that you all agree that the discussion had been absolutely fruitful, productive, and very interesting. I want to thank all the panelists and all the audience for their contributions, their questions, and their insightful comments. I want to conclude by saying that in spite of the barriers to progression, as Ronald pointed out, and Brooke alluded to, there is a lot of hope. Tackling gender inequality requires a multi-pronged approach that needs to combine with other initiatives such as training, public awareness campaign, engaging our male champions for change, policy legislative reform, so that we can increase and facilitate the conditions for tackling gender inequality, bringing women and men together for gender equality. Bar associations and law societies, as we heard, can play a fundamental role in encouraging their members to adopt and implement policies that can tackle gender inequality, address unconscious bias, promote flexible working, and improve work-life balance that benefits us all. These professional organizations have the authority, resources, and gravitas to catalyze and support changes within their own jurisdictions, including training the new generation of lawyers to be aware and to actively counter gender inequality at every level and in all areas of the profession. With those words, I would like to thank you all once again for being here and for all your contributions. And for this last part of this joint webinar, I would like to hand over to Stephen Denyer, our Director of Strategic Relationship at the Law Society of England and Wales, and to Karen Lam, Council Member of the Law Society of Hong Kong, to say the final words and to close in overall this very productive session today. Thank you very much to all. Over to you, Stephen.
Thank you very much indeed, Lizette, and thank you so much to all of the speakers on both sessions. So my name's Stephen Denyer. I'm the Director of Strategic Relationships at the Law Society of England and Wales. I'm based in London, but I've been a regular visitor to Hong Kong for more than 40 years now, there most recently in 2019. I'm very conscious, and the profession in the UK is very conscious of the depth and breadth and length of the relationship between the two law societies. I think what this joint session has illustrated very powerfully is the enormous potential for continuing ever closer collaboration between us, and we're extremely grateful to the Law Society of Hong Kong for hosting and doing so much to create this wonderful joint event. I've also been very struck by the diversity of speakers, not just the gender diversity, but also the mixture of in-house lawyers and lawyers from large firms, lawyers from small firms and other practitioners. And I think that's a real strength long-term of both our legal communities. It's really important for the profession worldwide that busy practitioners at every level of their career continue to be able and willing to contribute to events like this and to the very important work of law societies and bars. I think with the current challenges in the world, it's never been clearer that collaboration between law societies and bars is key, and that active involvement right across the profession in the work of bars can really add value, but also can enrich the lives and professional experiences of practitioners. So thank you on behalf of the Law Society of England and Wales. And for the last word, let me hand over to Karen Lamb.
Thank you, Stephen. Distinguished speakers, fellow members of the Law Society of England and Wales and the Law Society of Hong Kong. On behalf of the Law Society of Hong Kong, I wish to thank you for attending today's joint webinar. I'm sure that we've all learned a lot and gained useful knowledge through today's sharing, and have a better understanding regardless on the latest developments in cross-border disputes, and also an even bigger topic, women in law. Further to our President Melissa's opening remarks, we're very grateful to have the opportunity to organize this first joint event since the signing of the MOU in 2017 with the Law Society of England and Wales. I'm sure this is just a kickoff of our collaboration, as mentioned by Stephen, and we will definitely continue our effort to foster information exchange between the two associations. Although it is still not quite feasible to host face-to-face meetings and seminars at this moment due to the pandemic, with the help of technology, and as I was told to do a bit of advert, the Law Society of Hong Kong will be organizing 2 more webinars for our overseas friends upcoming in August and September, and you're all welcome to join us. So in these difficult times, law firms can face institutions threatening liabilities and legal risks. So if risk management is a topic of interest, we would like to invite you to join our webinar on risk management education, RME, to be held on the 2nd of August via Zoom. It is designed for all legal practitioners, regardless of the level of expertise, and this webinar will provide you an overview of our RME program and extend your understanding of risk management in the law firm setting. And the second webinar to be held in September is in relation to a very interesting topic of GBA. In addition to the Belt and Road Initiative, a major development for the legal service market in the Guangdong, Hong Kong, Macau, Greater Bay Area, which we call GBA. GBA comprises of 9 affluent cities in the Guangdong province, in addition to Hong Kong and Macau. So the total population in the GBA is over 86 million, and the GDP is, okay, let me get the figures right. It's $1,668.8 billion US in 2020 alone. So enjoying the dual advantages of one country, 2 systems, Hong Kong plays a very important role in the GBA development. To fully utilize the huge potential of GBA and to explore new opportunities for the legal profession, a webinar on the GBA development will be organized in September. I understand from our secretariat that the dates are to be confirmed. But eminent speakers from the government, and international organizations will join the Law Society speakers to share their valuable insights on this topic of the growing significance to the legal industry. So if you're interested in this topic, please stay tuned for further update. Without further ado, ladies and gentlemen, once again, thank you for joining us. And hopefully we can all meet again in person. Thank you.